3 months until the election, it's a race against the clock for opponents of restrictive voter ID laws and the multitudes of voters affected by them. Virginia's voter ID law cleared a significant hurdle yesterday. The state is among a handful with a history of voter discrimination that must have any election law changes cleared by the Justice Department under Section 5 of the Voting Rights Act. And the Justice Department did just that yesterday, approving a state law that requires Virginia voters to show ID, but accepts a broader range of IDs, including current Virginia student ID cards, utility bills, paychecks, bank statements, and concealed handgun permits. Meanwhile, in Pennsylvania, Republican Governor Tom Corbett's administration is refusing to cooperate with the Justice Department's review of its strict voter ID law, writing in a letter that it would not provide any information substantiating the state's dubious claim that 99% of residents possess valid ID, a claim rejected by many studies. Instead, Pennsylvania, in an apparent irrelevancy, urged the department to re-examine a 2008 voter intimidation case involving the new Black Panther Party. Here with me now is Degbole, acting president and director, counsel of the NAACP Legal Defense and Education Fund. Thanks for your time.
Good to be with you.
This issue is central to the integrity of the vote come November. A multitude of states have passed laws designed to keep people from voting. Virginia's law got a thumbs up from the Justice Department. Pennsylvania's, perhaps the most treacherous in terms of the outcome of November, is still being litigated. Where do we go from here?
It's a tricky story, Elliot, because there has been a nationwide effort to suppress the vote. And it's happened in a lot of different states. But I think that there is a distinction with what Virginia did as in contrast to what Pennsylvania did. Virginia's law, in a sense, expanded some of the forms of ID that were available, and so it's not as strict. It's not a photo ID law at all. As you mentioned, many types of identification, including identification without photographs, is permissible for voters to come through and cast their ballot. In contrast, Pennsylvania's law is really going to jam voters up on Election Day, and it was intended to do so. So the fact that Pennsylvania is not cooperating says something about that.
Now, the judge in Pennsylvania who upheld the statute, despite the state's acknowledgement that there has never been a single case of in-person voter fraud, attempting to prove that you're voting on behalf of somebody when you're not that person, said that the statute would not be a significant impediment to voting. Do you buy that?
From my perspective, I think that's magical thinking. There were plaintiffs in the case who obviously could not vote. They had tried many times to get the appropriate ID, and the state had not cooperated. In fact, the state hadn't cooperated until after the case was filed, and people learned the stories. One of them had marched with Martin Luther King for the right to vote. She's 93 years old, and when it became known that she was not going to be able to vote, then the state relaxed its law and allowed her to vote to take the story out of the news. But many people are going to get jammed up here, and it's anti-democratic.
Now, I think what troubles so many citizens who are watching this from afar, who do not have your legal skills, who do not understand the technical nature of a challenge to a statute like this, they're saying, wait a minute, there is not any evidence that there is a problem with voter fraud. This is a non-existent problem, so why suddenly this raft of statutes that are making it harder for us to show up and vote, if not the simple prejudicial reason they don't want certain groups of people to vote? So why can't the statute be struck down simply on that purpose that it has a sort of a dangerous motivation?
So in order to be struck down, it either has to be a discriminatory motivation. A dangerous motivation by itself doesn't pass muster. Essentially, you can't discriminate against a particular group. You can't discriminate against a racial minority, for example. You can't discriminate against women, but you can enact bad policy. This is both bad policy and discriminatory, and that's why you see a rash of civil rights cases that are trying to prove up the discriminatory aspect.
These laws are neutral on their face. Everybody has to show the same ID, and therefore, if I were the state of Pennsylvania arguing that the law is constitutional, I'd go in and say, wait a minute, everybody is obligated to provide the same voter ID, the same photo ID. This does not discriminate against any one group of people, no matter how you cut it. And the judge bought that logic.
I think that's right, except for a long time we've recognized in the law that you can pass a neutral law on its face that is either applied in a discriminatory way or has a disparate impact on a certain group of folks. This law is likely to have both aspects.
And because it has a disparate impact, as I think has been well established by the studies in Pennsylvania, the percentage of the voting population in urban areas, African Americans, seniors, who are likely to be lacking this ID is going to skew directly against the Democratic Party. And so should that not have been enough for a reasonable judge to say the Pennsylvania statute's unconstitutional?
I think there are two pieces to your question. One is the partisan piece, and the other is the racial impact of the law. The Supreme Court has sort of punted on these partisan challenges in a whole series of cases. They haven't really found a standard they like for partisan gerrymanders and the like. They're not wanting to wade in. On the racial discriminatory piece, the courts have been pretty clear that you can't enact a voting law for a discriminatory reason. Here, what you have to do is drill down and prove the motivation, and because they're neutral on their face, people sort of make believe that the law is doing something helpful. But even some Republican legislators in various states are saying that these laws are not about the integrity of the ballot. In Florida, the former Republican Party chairman said that the idea of fraud or integrity was all about a marketing campaign. It was not real.
And you had in Pennsylvania, of course, the state legislator who said, now that we've passed this law, the state will go for Romney, full stop, we're done. So certainly the intent as stated by one of the legislative voices was there and could be imputed to the entire statute. And again, I come back to where we began. Not a single case of actual voter fraud ever found in the state or prosecuted or investigated in the state of Pennsylvania. So as a judge, it certainly would have seemed to me, where you have no evidence of impropriety, the burden that you're imposing on people trying to exercise a constitutional right as inviolate as the right to vote, the balance should have come out in favor of easing the right to vote. But of course, the judge didn't do that. How do you see this litigation going forward?
Well, it's on appeal, and hopefully the appellate panel will see it differently. These cases are very tough to win because they're neutral on their face, but in this circumstances, as you've pointed out repeatedly, there is no evidence in favor of the law, and all of the burdens are felt by voters who want to have their voices heard. Voting rights are the highest order rights under our Constitution, and the idea that we would allow a system to block voters from getting to the polls really undermines everything that we all stand for as Americans.
And quickly, the state's claim in Pennsylvania that 99% of the voting public actually has the ID required, do you accept that as a matter of fact?
I think that's magical thinking, and I think that will be borne out as well.
All right, magical thinking. You're being very kind in your choice of language, given that this is TV. We would call it something else in a different setting. Debo Adegbile, I apologize, Acting President, Director, Counsel of the NAACP Legal Defense and Education Fund. Thanks for your time tonight.
Thank you.